think it's fair to say that we live certainly in a time of law, and not so certainly in a time of justice or even its constant pursuit. Laws and the bureaucracies that enforce them really flourish in Western democracies, certainly. The growth of statutory codes, regulatory regimes, enforcement of both, and of the legal profession itself has been enormous in places like Canada and the United States and other developed industrial democracies since World War II or maybe before. And consideration of legality or the role and the rule of law infuses much of what we discuss that seems, at first blush, not even strictly legal. War, identity as self, control over our own bodies, women's bodies especially, political leadership, power. All of these things have become very much the realm of law, of lawyers and courts. Culturally, we increasingly look to courts and lawyers to address or resolve difficult social issues and conflicts. So in all of that, it seems to me, in the culture that we loosely share between our two countries, the rule of law gets a lot of discussion domestically and internationally. Many of you personally, if you're law students, many of you personally are in a time of law in your own lives. Immersed in law school, in the early days or years of a whole professional life and a way of being, and probably seeking to learn what law is and what place it has in your lives. But from the very people who speak the most of law, we often hear remarkably little of justice. And I want to talk about why these two ideas, law and justice, often diverge, why there's space between them, why law, in fact, tends to submerge justice, both inside law schools and outside them, and what I think the relationship can and should be instead. So I'm going to start with the idea of justice, not what it is, but what our personal responsibility to it is. And next I want to say something about the importance of the rule of law. But then I want to urge on you, and this is probably the core of what I have to say this afternoon, I want to urge on you the inadequacy of the rule of law by itself. I want to suggest how we lawyers, law students, and law schools become complicit in elevating the rule of law over a sound conception of justice. And finally, I want to suggest how we might pursue the dual goals of the rule of law and justice, and to keep the first, keep rule of law, without accepting the absence of the second, the absence of justice. So let me start that project with one of my favorite Canadians, after Professor Martin and Gordon Perry. I don't know how many of you even know him or appreciate him as much as I do, but I'm talking about Leonard Cohen. Born in 1934 in the Westmount area of Montreal, poet, singer. And I'm just going to give you a stanza from a lovely poem that he wrote called Lines from My Grandfather's Journal, first published in 1961 in a collection called The Spice Box of Earth. Let judges secretly despair of justice. Their verdicts will be more acute. Let generals secretly despair of triumph. Killing will be defamed. Let priests secretly despair of faith. Their compassion will be true. You know, lawyers often speak and write of law in the language of law, or one of the languages of law. If we're good lawyers, we speak well in the language of law. But poets and musicians speak and write of life, and they do it in the languages of life. And that comparison, I hope, will help my project this afternoon. And to my mind, Leonard Cohen was a very good poet and musician. So what did Cohen mean with that sort of striking stanza? I think he was getting at a willingness to admit that at bottom, we have personal responsibility for justice, for victory, for faith. We must engage those qualities personally and advance them personally and try to enact them in our own lives. We can't rely, you and I, law students, lawyers, law professors, we cannot rely on any institutional momentum or external force or ally out there to achieve the ends of justice. Yes, there are courthouses, there are courts, there are lawyers, there are judges, and all the elaborate segmentation of responsibility for the pursuit of justice or whatever we're doing in those courthouses that goes along with these institutions. But these institutions really can't be relied on to do the work of justice for us. That requires our whole and personal engagement. Yes, there are armies and the elaborate apparatus of command and deployment of warriors and materiel. But we can't rely on those either to do anything more than to destroy. If we want to define and achieve the constructive rather than the destructive, to achieve something worthy of the word victory, that requires our whole personal engagement in construction of consensus and healing and peace, not just in destruction, defeat, and death. Yes, there are churches and other places of worship, religious traditions and their dogma, but absolutely no edifice, mosque, temple, church, and no catechism produces faith. That requires, again, our whole and personal engagement with each other, with our fellow human beings. The despair of which Cohen spoke, I think, means a recognition that we cannot hide behind institutions or a segmentation of functions within them that allow us to deny personal responsibility for the whole. We can't just point always to others as responsible for failures. Leonard Cohen, by the word despair, also may have meant a kind of humility about not just institutional limitations, but also about our own limitations. Do some of you know Brian Stevenson, the remarkable American lawyer down in Montgomery, Alabama, who runs the Equal Justice Initiative, and he's lately written a book called Just Mercy, which is even more recently out as a movie. If you haven't seen his TED Talk or seen him elsewhere on YouTube or somewhere else online, he's worth listening to and considering. And one of the things he says often is that we as lawyers, as law students, we must be proximate to vulnerability and poverty. We have to be proximate to poverty and pain and vulnerability. We must draw closer to it. And what Stevenson means is that we can't rely on institutions or others, much like Cohen. We must do what is uncomfortable and do it personally. Then there's a chance. From the verdict that we accept as our acute personal responsibility, a chance for justice. From taking personal responsibility for killing, an end to killing and a path to victory. From personal compassion, maybe a pathway to deeper spirituality and humanity. In short, we have agency as law students, as lawyers, as citizens. You have agency in your profession right now. I do, or should. And that's not just empowerment, but also obligation, rooted in the conflict that pervades our systems of law. If we're only lawyers, we're not enough. We must be dreamers and actors. We must be both afraid and fearless. We must be both leaders and followers of those who see more clearly, or feel an injustice more acutely, perhaps, and nearly than we. We must be humane agents, not for law alone, but for justice. And let me be clear and maybe a bit depressing about this. If, as lawyers, we're not humane agents for justice, then very quickly we're agents of injustice in this profession. For us as lawyers, including all of you, complicity in injustice is but one lapse of conscience away on any given morning, or worse, one lapse into complacency and unconsciousness away. So I wanted to say something about the importance of the rule of law beyond those initial thoughts about personal responsibility for justice. Look, authoritarians, the powerful, and bureaucrats in law enforcement and the judiciary focus often on the rule of law. They claim quickly to support it, and they sometimes justify oppression with it. Let me give you one visible example. And maybe I'm picking on him more than I should. I only mean him as an example. But the Attorney General of the United States right now is a man named William Barr. He gave a speech just a few months ago in November to the Federalist Society. And in it, he, at one point in the speech, he objected to the resistance ethos of the American left, as he described it, with respect to the Trump administration, and attributed to resistors a holy mission to use the coercive power of the state to remake man and society in their own image, according to an abstract ideal of perfection. He then compared conservatives and extolled the rule of law together. And I'm going to read verbatim a longer passage of that speech. Conservatives, on the other hand, do not seek an earthly paradise. We are interested in preserving over the long run the proper balance of freedom and order necessary for healthy development of natural civil society and individual human flourishing. This means that we naturally test the propriety and wisdom of action under a rule of law standard. The essence of this standard is to ask what the overall impact on society over the long run, if the action we are taking or principle we are applying in a given circumstance was universalized. That is, would it be good for society over the long haul if this was done in all like circumstances? For these reasons, conservatives tend to have more scruple over their political tactics and rarely feel that the ends justify the means. Okay. So note some of Attorney General Barr's key words there. Preserving, proper balance of freedom and order, natural civil society. And then he ascribes to the rule of law an inquiry into the overall impact on society and what is good for society. And he concludes his argument by asserting that conservatives have more scruples in political tactics and, again, rarely feel that the ends justify the means. Now, it's hard to miss in those words a fundamental contentment with the status quo in that conception of the rule of law and of its importance. Again, the focus seems to be on preserving what is proper and natural words that implicitly ratify and don't challenge what simply is at the moment. I hazard to suggest that many of those who are quickest to protest change by saying that the ends do not justify the means actually often are people of means who think that the greatest end is that they remain in the position they currently hold. They tend to equate their position in society with a natural and proper structure of society itself. If you're a have rather than a have-not, it's not surprising in the sense that you might focus on police, on law enforcement, on law and order, on those aspects of the rule of law. Now, to stay with Attorney General Barr for just another couple of moments, after that speech, I was unsurprised by his comments less than 3 weeks later at a U.S. Justice Department award ceremony for distinguished service in policing. And there, Attorney General Barr explained that civilians need to, and now I quote him, start showing more than they do the respect and support that law enforcement deserves. He went on, if communities do not give that support and respect, they might find themselves without the police protection they need. Now, there wasn't a word in that talk about the respect that the police should show for the communities they serve and that pay them. I don't disagree at all with the idea that the police should have our respect. I also think the police should earn that respect and should demonstrate their own respect for us, for all the communities they serve. But in Attorney General Barr's formulation there of the rule of law, there was no reciprocity, apparent at least. No justice, veneration of the one to the other, but no mutual respect and love. The wonderful French thinker and writer who died way too young, Simone Weil, had a sufficient and beautiful reply to that view that I think Mr. Barr captured when she wrote in 1940 that it is impossible to love and be just unless one knows the empire of force and how not to respect it. But I don't want to kid you, and I don't think we ought to kid ourselves. We can't let the fact that bureaucrats and authoritarians so often find refuge in the rule of law obscure the truth that the rule of law is an essential starting point. Only that, but still essential for any free people. Consider what the absence of rule of law looks like and how it affects us, real people. Here I'm relying on the United States State Department's travel advisories and other reports. There are many places on this world, Somalia and Venezuela are just two examples currently, in which it is unsafe, I mean really physically unsafe, to take a taxi cab from the main international airport into the nearby large city. There are places where illegal roadblocks, ambushes, kidnapping, piracy, rape, and murder are commonplace on public thoroughfares. Places where the police response time, even to serious crimes, is measured in hours, if at all. That is, many countries have poorly trained, understaffed police that struggle to provide even rudimentary law enforcement services. The United States State Department advises, for example, not traveling anywhere between cities in Honduras after dark, or by any form of public transportation at any time. There are places where the police themselves regularly demand cash bribes on the spot. In Mali, for example, again, our State Department advises, and I'll quote it, if asked to stop by the police in Mali, stop only in well-lit areas or places and where several officers are posted. Worse, police participate in extrajudicial killings on the streets in some countries. The Philippines and Brazil are examples. In Papua New Guinea, you have a total of 4,500 police officers in a country of 7 million people. That works out to about 6.4 police officers per 10,000 people. And Port Moresby, the capital of Papua New Guinea, and other large cities have some of the highest crime rates in the world. Look, just by comparison, take New York City. Papua New Guinea has 7 million people total, the city of New York about 8 million, but it's got 34,000 New York Police Department officers, or about 42.5 police officers per 10,000 people. As to public corruption, which also erodes rule of law, the nonprofit Transparency International publishes an annual corruption perception index drawn from 13 sources. The worst score on that index, the corruption index, is 0, and the best or cleanest government would be a 100. No country on the face of the earth scores over an 85. Canada is one of the best at 81. Most of the world on Transparency International's interactive map is red or orange in color, meaning widespread public corruption, and scores on the index well below 50 and often in the teens. In short, without basic rule of law, people cannot move freely, interact with any government official without fear, or expect any protection from violence other than their own violent self-defense or vigilante justice. The absence of rule of law is the constant presence of fear and physical and moral insecurity. It cripples, that is, the absence of the rule of law in this way cripples or prevents outright cooperative social relationship to other people. I think the rule of law then is essential to humane development, to a life worth living. The absence of that sort of basic rule of law is itself a form of oppression. And yet, the rule of law really is inadequate alone, isn't it? I closed my second book with words I really believe. And they are, the rule of law is essential, yes. But law without justice is only rule, and oppression waits there also. Law not infused with justice truly is just a set of rules, perhaps without moral validity or even content. Consider some practical examples. Hungary today has weakened judges' security and given the legislature complete control over the Constitutional Court as a matter of law. Much the same has happened in Poland with the independence of the judiciary, especially the Constitutional Tribunal, seriously undermined, according to the UN Human Rights Committee. Hungary also has enacted whole laws to harass and defeat just one man, George Soros. Literally, one man. Himself born in Budapest, Hungary, and a Hungarian by birth. Worse, Hungary and many other nations tolerate or enforce discrimination against LGBTQ citizens, against women, against religious minorities, against ethnic minorities. Now, as to religious minorities, it depends on where we are. Sometimes it's the Jews who are oppressed, the Muslims in other places, Christians, Hindus, all depending on where. But the repression is a function of law. Looking back, apartheid in South Africa, rule of law. The historical segregation in American public transportation, public accommodations, housing, almost every aspect of U.S. life, rule of law. the exclusion of women from voting and juries in Canada, in the United States, and in many other countries until into the 20th century. Rule of law. Canadian discrimination against Indigenous people, children and women especially. Rule of law. The same with Indigenous people in the US, Australia, and many other places. The United States holding about 24 so-called forever prisoners at Guantanamo without any charge being laid against them, now many of them for 18 years. Rule of law. US torture of terrorism suspects and combatants and non-combatants at secret foreign sites controlled by the CIA, done elaborately pursuant to the rule of law, as interpreted by our executive branch. Slavery for more than 3 centuries in North and South America, including the United States and the Caribbean. Rule of law. The Holocaust. Rule of law. Frequently then, the world sees the presence of the rule of law, but the absence of justice. The utter absence of justice by any humanely acceptable measure or definition. So to give William Barr and other defenders of the rule of law their due, it would be dangerous and foolish to imagine the presence of justice in the absence of the rule of law. There simply can be no earthly justice, it seems to me, present if basic rule of law is absent. But justice cannot be only an imposed act of will. It isn't only an imposed act of will. Outside the basic reality of law's rule, law's stability, that, as I said, makes physical and moral security possible. Basic rule of law is necessary for a full expression of individual humanity and for cooperative social relationships to thrive at all. No mere imposition, though, of one person's will on another ever can be justice, no matter how closely adheres to the rule of law, no matter how benevolent or well-intentioned or enlightened the imposer of that will may claim to be. So a common problem is not seeking presence of justice in the absence of law. It is the presence of the rule of law, but the absence of justice. What then is our complicity as lawyers and law students and law professors in creating the presence of the rule of law, as well as we have, but the absence of justice, as often as it is? We really do, I think, too often fail to distinguish the rule of law from justice. I've tried to demonstrate that the two really aren't the same. But we in law schools focus on the rule of law, and in society more broadly. Indeed, we focus on the rules, plural, the rules of law in law school, and those come to stand over time for the rule of law. With a necessary focus on the rules of law in law school and practice, in an increasingly complex legal regime, we reinforce the concept of rule of law, but often overlook what those rules produce or tolerate. Justice just gets omitted. Rules of law become the rule of law, and we never get to the core question of justice. We are taught that we can understand and question judicial decisions, understanding them before questioning them. But then often we stop at trying to understand them, because debating whether they're right or wrong seems a matter of subjective opinion, the field of lawyering. And we open that field of lawyering and try to equip students to enter it on either side of a dispute as clients' interests may dictate. But we really don't encourage students to settle on, or even to think seriously about, whether one argument may be just and to what extent, and whether other arguments may be unjust or less just and to what extent. We don't admit, let alone encourage, moral agency as lawyers. And we're taught very little or nothing about questioning legislative judgments, other than for clarity. These we ascribe to the field of democracy. We spend very little time in law school asking what democratic choice and processes mean, or to whom democratic choice and processes, as we Canadians would say, really are open, and on what terms. In all, we're taught a culture of argument in law, a culture of formal and organized dispute in law school, which look, I concede is good. It's even wonderful at some level. Civilized people can and should have disputes, and respectful legal argument is a high form of social engagement and progress. But it's not enough if it's a culture without content beyond rule. All arguments proceed from and enact values, not just outcomes that a client or we prefer. Yet we often don't consider those values. Shouldn't justice be our first value? Itself a composition of other values. But we spend very little time on that subject, that value and cluster of values in law school or in law practice. Many law students and lawyers have a hard time defining and distinguishing between, let's say, distributive or allocative justice on the one hand and procedural justice or moral justice by comparison. We commonly may speak of social justice, for example, but we neither offer nor require much rigor in defining that and in considering how practically to enact social justice. Conversations and efforts often are limited to redistribution of privileges or advantages among specific segments of society, for example, within our profession itself. We do very little, I think, to help students define a term like social justice more generally, and to think about it at the root in a more structured, universal way, rather than in one or another specific context. Put a little differently, when we speak of social justice, our orientation often is to ask how law can improve justice incrementally. We don't ask instead how justice can improve law fundamentally. We spend even less time considering the ways in which systems, institutions, and customs work together in predictable ways to reproduce advantage for some groups and to sustain and reproduce disadvantage for other groups. This systemic injustice is only beginning to find its place in law school curricula and in experiential education as an overt or express topic of study and work. We spend so much time on law and so little time on justice that we come to assume that the two can be equated, if we even consider justice at all. So how then do we insist upon and enact the presence of justice without the absence of law? Now, I'm only trying to start a conversation here, not to end one. I don't have an answer. And even if I did, I wouldn't have the time to try to work that through with you. But I have some preliminary thoughts that I'll share. One thought I can offer goes back to the Austrian and English philosopher Ludwig Wittgenstein, and to the humanities more generally. In the only two works that Wittgenstein produced in writing in his busy lifetime, and one was published after his death, he perhaps can be understood to present an overarching argument against scientific explanation as an end goal. And his argument instead was in favor of not just the humanities, but of philosophy as a way of life. Philosophy as an ongoing act of being, not as a theory or a body of learning. And in that way, he suggested that the pursuit of knowledge, which he equated or correlated with scientific investigation and explanation, he suggested that the pursuit of knowledge is not the best end of the human mind. rather that the acquisition of wisdom is the better end for the human mind, and that knowledge and wisdom aren't the same. Really quite fine essay just last month in the Times Literary Supplement about Wittgenstein. And I'll quote from that. In our ever-extending observance of the idea that knowledge, not wisdom, is our goal, that what matters is information rather than insight, and that we best address the problems that beset us, not with changes in our heart and spirit, but with more data and better theories. Our culture is pretty much exactly as Wittgenstein feared it would become. I can't put it quite that well, but this is indeed called an information age, not an insight age, right? And I do think we live in a time of law, not a time of justice. And perhaps we shouldn't settle for any of that. You know, as to the practice of law, I've come to believe, not that your Gord would agree with me on this, I at least have come to believe that knowledgeable, technically competent lawyers abound. Those who know rules and cases and procedures by heart, those who can recite eloquently and confidently a phrase in court, they're relatively easy to find. But lawyers with good judgment and humility are really quite rare. And it's the latter, it's judgment, not knowledge, that clients should value most. Not the presence of judgment in the absence of knowledge or skill, of course, but judgment and skill present together. That sort of judgment requires humanity. It requires at least a commitment to think about justice, to seek it, to pursue it. And that commitment to humanity is the very thing that the study of humanities expands and nourishes. Justice, I think, starts with thinking and difficult and humbling self-examination with the purpose of understanding not only ourselves, but everyone, understanding the whole human experience. Judgment and justice do not start with memorizing cases or rules of procedure. Indeed, judgment and justice can die there, or at least become absent, even as the rule of law then flourishes. Hannah Arendt echoed Wittgenstein in a sense and underscored my point in her posthumously published The Life of the Mind in 1977. And she said that while acquiring knowledge is, as she called it, a world-building activity, thinking, by contrast to acquiring knowledge, thinking undoes every morning what it had finished the night before. Note the humility in that. The willingness to undo in the morning everything you thought you had done and accomplished the day before. Knowledge builds the sphere of law and its rule, builds legal careers. But really only by thinking, by self-examination and re-examination, by pausing to consider again the basic foundation of our structures, can we hope to advance justice and good judgment. It's not an accident that I turned to Wittgenstein and Arendt and Leonard Cohen. These were deeply humane thinkers and writers in the humanities. Now, I don't dispute for a minute, and indeed I honor the role that the social sciences play in the study and practice of law. It contributed a great deal, and to a large extent have taken over the legal academy. But I've marked myself down publicly now several times as continuing to hope that the humanities retain their place in the study of law and even remain law's intellectual and spiritual home. So just as we might follow Wittgenstein in valuing wisdom over knowledge, insight over information, and as lawyers, judgment over mere technical mastery, so too we might reconsider how to value justice first, not law in and of itself. Perhaps we need to become, if we're not already, a student of the humanities, or at least a student of humanity. Any of us can do that. A student of humanity and inhumanity. Studying humanity, I hope, with aid of the humanities, is a very personal responsibility. We can't shirk our agency in that study. We cannot rely on courts, on our law schools, on other institutions to explore and enact humanity or to fight inhumanity. We must examine the pain we have felt and the pain we've caused. Humility again. And then think and act from there. Brian Stevenson again, he calls us to be proximate to poverty and pain. Well, they're both within us. But they're often most distant there. We bury them. And so maybe a place to start is by allowing proximity to that which we've buried within. And then understanding how that connects us universally to every other person on the planet. That is to say, ultimately, we, each of us alone, must be honest students and examiners of ourselves. We must crack open our own inhumanity, each of us, and find the full humanity within us. Maybe the essence of justice is there to be found. And maybe we can enact it outwardly from there. And I don't think we need to worry in this cracking open inhumanity within us. We're not going to crack. Only our inhumanity will. We'll be stronger for exploring our full humanity, and thus the full humanity of everybody else, in spite of our faults and theirs. We'll be stronger for seeking justice by cracking open that inhumanity and humanity. We'll just end with Leonard Cohen again. There is a crack in everything. That's how the light gets in. Thank you.